All right, well, for our final speaker, okay, we're going to start. No, we're going to start, okay. All right, so for our final speaker, she really doesn't need an introduction because she's such a well-known advocate in our community, but if you live under a rock, I guess, I'll just share a few remarks. Commissioner Feldblum, after getting her JD from Harvard, clerked for Supreme Court Justice Harry Blackmun. She's had several titles. She was a legislative counsel for the American Civil Liberties Union. She is a professor at Georgetown Law, where she also founded the Federal Legislation and Administrative Clinic, and most recently was appointed and confirmed by the Senate to the Equal Employment Opportunity Commission with a term ending in July 2013. Commissioner Feldblum has also done many great works with the disability community, including drafter and negotiator of the ADA and the ADAAA in 2008, the Amendments Act. She was also the founder and co-director of Workplace Flexibility 2010, and is a huge contributor to the LGBT community, is the writer of the Employment Non-Discrimination Act, and is the first open lesbian of the EEOC Commission. She has many titles, but a title I give her is Discrimination Buster, because she always fights for equal rights, fair treatment, and progress. So without further ado, I present Discrimination Buster, my friend and badass, Commissioner Feldblum.
Thank you, and I am going to take that mic from you.
Thank you.
Okay. Put it on me. Oops. Oops. Great. Well, actually, I thought Kevin was also going to say the title I gave her, which was Boss, because Kevin worked for me as an intern, fantastic intern last summer, and then continued working through the fall when he went back to law school. So very much appreciate that. He's now actually, over the summer, he's going to be working at a law firm that my colleague, Commissioner Lipnick, had worked at before, and as I just found out a week or so ago, the law firm did call the staff person for Commissioner Lipnick to ask about Kevin, to say, so what, should we think we should hire this person? And that staff person was like, yeah, he did an awesome job in Commissioner Feldblum's office. Okay, so this is how networking happens. Okay, that is why this type of group is so important, for you to meet folks. And, you know, I looked at your list of folks who came, you know, through this conference. You basically had all the heavy hitters in terms of disability rights. Any of you, if you don't have an internship over the summer already, you should be emailing the people that you heard from. And just say, I heard you at the conference. Is there any place in your office, or if not in your office, in the office of someone else that you know? There's absolutely no one who came to this conference who should not be able to get a summer internship. Okay, so that's I'm just encouraging you to do that. All right, so what I'm going to talk about, my title here for you for your closing speech is, We are all disabled and why we need to say so, and we are not all disabled and why that matters. Or at least we are not all equally disabled and why that matters. Okay? And in terms of the first part, we're all disabled and why we need to say so, why we need to come out with that, I'm going to talk a bit about the 2008 ADAAA, the ADA Amendments Act, a little bit about the development of that law and how that was trying to get to the point that we are all disabled. And then I'm going to talk about what's happening right now, which are the regulations that the Department of Labor is working on to implement Section 503 of the Rehabilitation Act, which requires government contractors to use affirmative action in employing and advancing in employment people with disabilities. And in that context, I'm going to talk about how I don't think we should have necessarily the same broad definition of disability that we have under ADA. Okay, so those are the two parts of my talk, and I certainly hope I have that. I love that you were brainstorming before about things that you could do. I hope that if you have a policy subcommittee of your group, that policy subcommittee focuses on these Section 503 regulations. Personally, I think there's no reason why the National Association of Law Students with Disabilities can ask for a meeting with the White House about the Section 503 regulations. No reason why not, except that you would have to have a subgroup that focused on it and knew what you wanted to say. Okay? But you are an association. You're a group. You can ask for meetings. So, my message to you is that both individually to put yourself forward, for summer internships, jobs, etc., and organizationally to put yourself forward. All right, so the first, we are all disabled and why we need to say so in terms of, and using the ADAAA as an example. So Kevin correctly noted that he created for me Discrimination Buster. So on my Twitter profile, now how many people here are on Twitter? Okay, how many people here are not on Twitter? Okay, everyone who's not on Twitter, you should just go online, create an account. It's totally easy, assuming that you've got something that makes Twitter accessible to you, and it should be, I'm assuming, hoping. Go on, and then you can follow me at Feldblum. Okay, so right there, I'd get another 15 followers right here, plus everyone who's on Twitter, obviously. You want to go home right now and, whatever, do it on your phone. But so, for example, on my profile, it says the first out lesbian commissioner of the EEOC, parentheses, with a disability. Now, no one's going to know that I have a disability in terms of if they just meet me because I don't have one of the manifest disabilities. Right? I have anxiety disorder that's medicated, absolutely a disability under the ADA. If, in fact, someone decided to discriminate against me because of the anxiety disorder, I'd be covered under the ADA. But people with the types of conditions like anxiety disorders or heart conditions or cancer even do not necessarily think about themselves as people with disabilities. Even though they should, in terms of the legal definition, they are people with disabilities. And certainly, if they ever experience discrimination on that basis, suddenly they would be thrilled to find out that they are a person with a disability and they can't be discriminated against on that basis. Okay, we shouldn't be waiting till people are discriminated against for them to understand that they are also persons with disabilities. Okay, so let me tell you some of the story of the ADA Amendments Act in terms of this concept of we are all disabled and why we need to say so. Mm-hmm. So some of this is coming from, I printed off some pages this morning of an article that I wrote with two other people in 2008. So this is in the Texas Journal on Civil Liberties and Civil Rights. It's basically the story of the ADA Amendments Act of 2008. So any of you who are interested in more detail, you can just get it off of the Texas Journal. But one of the things that I did in this piece was talk about the history, the development of the ADA that then resulted in the ADAAA. And I often say, I don't have kids, I have laws. Okay, instead of it's a boy, it's a girl, it's a law. Here it is. And then I often say the way kids go off to school and they meet friends and suddenly they come home and they have purple hair and they have nose rings and the parents are like, hello, who are you? Laws go off to court and they meet judges. And judges say what the laws mean and suddenly the people who drafted it don't necessarily, it's like, who are you? Right? So that's what happened to the ADA in terms of the definition of disability, that the courts really constricted the definition. But part of why the courts did that was because the agency, the Equal Employment Opportunity Commission, the agency that I'm now one of the 5 commissioners of, that agency, when it issued regulations in 1991 to the Americans with Disabilities Act, they issued regulations to the definition of disability that were very different from the regulations that had been issued on the previous bill, the previous law that ADA was patterned on, Section 504 of the Rehabilitation Act. Those regulations for the definition of disability, which was physical or mental impairment that substantially limits one or more major life activities, the regulations were very sparse on that. The Department of Justice, when it issued regulations to the ADA in 1990, they have jurisdiction over Title III of the ADA, public accommodations, very sparse in terms of the definition of disability. The EEOC had several pages. They had a definition of what substantially limits means. Severely, significantly restricts. It focused on how it had to be an individualized assessment. It talked about major life activities. I mean, it sort of went on and on. And so what the agency did set the stage for what the courts ended up doing then, which was this very individualized assessment of whether you were a person with a disability. So actually when the White House called, sort of out of the blue, to be an EEOC commissioner, and I thought, well, you know what, this will be like, I think I'll go with this kid to kindergarten. You know, like I'll actually go to the agency and help write the regulation so we can get it going well. And that was one of the main reasons why I wanted to be a commissioner and took the appointment. And in fact worked with my colleague, my Republican colleague, Commissioner Lipnick, to develop bipartisan regulations that implemented the deal that had been struck in Congress. Okay, so let's talk a little bit about the deal, because it reflects this point of we are all disabled and we need to say so. So what you had in the, the courts, ultimately the Supreme Court, in a trilogy of cases in 1999 that said you have to take into account mitigating measures in order to determine if someone is disabled. So for lots of people with medical conditions, where if they took medication, the condition was no longer substantially limiting them, they were no longer covered. And then in 2002, the Toyota case, the Supreme Court held that substantially limits is a very demanding standard. Okay, so it was really cutting out the number of people who were covered under the definition. And in 2002, Steny Hoyer, Congressman Steny Hoyer, who had been one of the main people working on the original ADA, submitted an op-ed to the Washington Post that was published in January 2002, critiquing these decisions, and said at the end, quote, "Our responsibility now is to revisit both our words and our intent in passing the ADA. In matters of statutory interpretation, unlike constitutional matters, Congress has the last word." Okay, because this is how, when I say it's a law, right, what happens, the way you get to the law, is you have essentially policy, politics, text, meaning statutory text, and law. That's the process. You start with an idea, a policy idea. People with disabilities shouldn't be discriminated against. Okay, that's what you want to have happen. Politics is what determines how much of what you want actually gets enacted into the text. Okay, that's the politics. And the clinic that I set up at Georgetown, Federal Legislation Administrative Clinic, was very much about teaching students how to go from policy to text, taking into account the politics. Okay? Once you get the text, which is the text of the statute, then text becomes law by the actions of various other entities, agencies that issue regulations, lawyers that interpret the statute for their clients, and ultimately courts. That's what makes text into law. And that's why it's so important to learn the rules of statutory interpretation, administrative law, etc. Now, if what the courts say the law is not what Congress or the state legislature wanted in the first place, the process starts over again, right? And now they're redoing the words. Now, it's not easy. Congress doesn't like to revisit things that it did before. So in 2002, Steny Hoyer was saying we need to revisit these words. But the politics were not in place to have that happen. Okay? The politics did not shift until 4 years later. And again, this is where it all comes down to individual people sometimes. Didn't shift till 4 years later when Congressman Sensenbrenner very conservative Republican from Wisconsin. His wife, why am I blanking on? Cheryl, thank you. Cheryl Sensenbrenner, who was the head of the board of the American Association of People with Disabilities, right? So herself a person with a disability. She had enough of those breakfast conversations with her husband. And in 2006, he indicated his willingness to sponsor an ADA Restoration Act. Okay, so in September 2006, the last day of the session that the Republicans were still in power in the House, Congressman Sensenbrenner and Hoyer introduced an ADA Restoration Act. Then November 2006, right, House changes, Democratic control, and so that's when I got involved through the clinic. The clinic represented the Epilepsy Foundation that was co-chairing a working group to work on the ADA Restoration Act. And on July 26, 2007, the 17th anniversary of the ADA finally got the beginning of its sibling. See, that's the unborn child. It's just a bill. See, I believe in unborn children. No, okay. Don't run. Okay, so July 26, 2007, Congressman Hoyer and Sensenbrenner on the House side, Senator Harkin and Senator Specter was still in, introduced these companion ADA restoration bills. Now, in terms of what that bill said, the ADA Restoration Act, what it did was say there's been all this difficulty with substantially limits major life activity. So we're just going to lop those terms off. And we're going to say a disability means a physical or mental impairment, period. Disability is any physical or mental impairment. And you're covered, even if you don't have a physical or mental impairment, but you're regarded as having a physical or mental impairment. So it had the same three-part. You have a current impairment, a record of an impairment, or regarded as it, but it was all impairment-only standard. So substantially limits and major life activity gets lopped off completely. That was the original ADA Restoration Act. House side held a hearing in October. Senate side held a hearing in November. I testified at both of those hearings. And in this article, I insert the entire testimony from the Senate side. Okay, so now, because Congressman Sensenbrenner was one of the lead co-sponsors, the ADA Restoration Act had a fair number of Republican sponsors, as well as Democratic sponsors. Upon introduction, the House bill had 143 co-sponsors. I think it had gone up to about 177 by the time we were testifying. And obviously, an incredibly broad definition of disability. It was simply any physical or mental impairment. No level of severity at all attached to it in the words. Okay, so I go through the history, blah, blah, blah. I talk about, in this testimony, how in the original ADA, the third prong, the regarded as having a disability, was intended to cover anyone with any physical or mental impairment who experienced discrimination based on that impairment. That is, the act of discrimination was supposed to create the coverage under the third prong of the disability in the original ADA. Right? So I quoted from committee reports from 1990 saying, a person who is excluded from any activity covered under this act or is otherwise discriminated against because of a covered entity's negative attitudes towards disability is being treated as having a disability which affects a major life activity. Right? That in the original ADA, it had a physical and mental impairment that substantially limits one or more major life activities, record of such an impairment, regarded as having such an impairment. The way those of us who'd been working on drafting the original ADA, understood that third prong was if you had even the most minor impairment, but if you were discriminated against because of it, that clearly meant that that person was treating you as substantially limited in whatever activity you were being discriminated against. Right? So they didn't let you in to the restaurant because you're wrist was bent in some way, it's like, that's it. They were clearly seeing you as substantially limited in the major life activity of eating in a restaurant, right? And so the act of discrimination created the coverage. So in that sense, we are all potentially disabled because we all have some impairment or another. And if we experience discrimination on that basis, then under the original intention of the ADA of 1990, we should be covered under the regarded as prong. Right? So that's what I said in the course of my testimony. That was the original intent. Okay? And then at the end of the testimony, I then went through all the ways in which this had been cut back by the courts. And I said, how did this happen? How did it get so cut back by the courts? How did a statutory definition that members of Congress and disability rights advocates felt would ensure protection for a broad range of individuals end up being the principal means of restricting coverage under the ADA? Right? Those words ended up being the things that the courts used to restrict coverage, has to substantially limit. Right? And then under the regarded as, the courts imported this range of jobs idea. So it's not enough that one employer didn't want to hire me because, let's say, of that risk, that I now have to show that a whole number of employers would have not hired me. And that's what the courts read into the third prong. So I said, how did that happen? And I wrote, there's a range of academic literature on this, including some that I've written, but let me point out here simply one observation. From my reading of the cases, it seems to me that the instinctive understanding by many courts of the term disability is that it is synonymous with an inability to work or function, and concomitantly, that people with disabilities are thus necessarily viewed as significantly different from, quote, the rest of us. Okay? That courts were thinking, I know who people with disabilities are. They're those other people. I mean, they're not me and my family. Right? So, yeah, it's the people who use wheelchairs or who are deaf or blind. Those are people with disabilities. But everyone else is not. You know, and one of the cases that so struck me was a salesman with had had a heart attack. And then he came back to his job, and he was not given the same jobs, the same sales, route, etc., clearly being treated differently, brings the case, being discriminated against based on disability, and the judge says, literally, this is in the opinion, he says, I've had a heart attack, I'm not disabled, because that judge and so many others assumed that disabled meant unable to work and unable to function. Now, understandably, to some extent, some courts thought this because they also heard cases where people were asking for disability benefits, right? When they literally could not work and they were asking for benefits from the government or from a private disability plan. So in that context, yes, disability meant unable to work. But the whole point about the ADA was it was about people with disabilities who could work. But the judges were putting this perception of disabled means unable to work, and that's other people and not us. So part of what the ADA Restoration Act was trying to do was to totally cut that off at the pass and say, no, disability is just any physical or mental impairment. Now, as I ended the testimony, actually, this was in the oral testimony. Oral testimony was just 5 minutes. One of the things that the business community kept saying is, this definition is so broad, it's crazy, right? Any physical or mental impairment. So I said, so in conclusion, let me address a concern raised by Ms. Olson, Camille Olson, who's the main person for the business community, that the approach of the ADA Restoration Act will undermine the cause of people with disabilities because the law will no longer cover just the, quote, truly disabled, end quote. This room is filled with people with disabilities who want Congress to pass this bill. They don't believe this bill sets back their cause. Why not? Because they understand there is no set of, quote, truly disabled people and then all the rest of us. We all exist along a spectrum of abilities. It is true that many of us might never experience discrimination because of our physical or mental impairments, while others of us may experience significant discrimination. But that is not because some of us are truly disabled and others are not. It is because the type of discrimination that some of us will suffer and others of us will not. There is no us and them. There is simply a vision of equality and justice. It is time for Congress to restore the ADA and have it fulfill its true promise. Thank you. So that was my testimony before the Senate committee, arguing for a bill that defined disability as simply physical or mental impairment, period. Now, for those of you in the room, is that what the definition of disability was in the ADA Amendments Act? Any of you who have studied this? Do any of you know? No, it's not. Okay, because even though this had any number of Republican co-sponsors, there was no way that the business community was going to, let that bill go through. But what they then did was enter into basically 3 to 4 months of intense negotiations with us. So the business community and the disability community sat down and worked out a deal. And that deal became the ADA Amendments Act. In fact, part of the deal is why it has such a bland name, and therefore called the ADAAA, ADA Amendments Act, because they didn't want it to be called the Restoration Act, because that sounded like the one that was introduced, and they wanted to make sure people knew it wasn't that one. So we came up with all types of different names. Everyone didn't like it, and finally one person said, let's just call it the ADA Amendments Act, because it does amend the ADA and it doesn't say anything else. So that's true. But then we have ADAAA, which is, but whatever. That was part of it. So what was the deal? The basic part of the deal was, number one, that we would capture the concept of an act of discrimination could cause coverage under the third prong. And the third prong of the definition of disability became essentially an impairment-only prong. So regarded as having a disability as described under section, and it's another section of the law, and that section says, if you are discriminated against because of a physical or mental impairment, that establishes the coverage. And the only exception are for impairments that are both temporary, that'll last less than 6 months, and minor. Okay, so basically every other impairment that's not both temporary and minor, you are covered if someone ends up using that impairment against you. Okay, so in terms of who's a person with this disability under the law right now, from my perspective, practically every person in the United States of America. Because every person has some physical or mental impairment, and if they experience discrimination on that basis, they would be covered. Now, part of the deal, though, was that those folks would not get reasonable accommodation. Because part of what the business community was concerned about was providing reasonable accommodations, and they wanted that group to be more defined. So the deal was, fine, under the regarded as prong, there'll be no reasonable accommodation. Reasonable accommodation will apply to people who are covered under the first prong. And as part of the deal, the same language of a physical or mental impairment that substantially limits a major life activity was the definition, so that remained the definition of disability. Physical or mental impairment that substantially limits one or more major life activities. But then in the text itself, Congress put in certain other provisions. One, you don't take into account mitigating measures when you decide if something substantially limits. Two, as soon as you're limited in one major life activity, that's it, you're done, you're covered. Major life activities included major bodily functions, like your neurological system or your musculoskeletal system. And for conditions that might be episodic, you look at the impact of the condition in its active state. All of these things are pieces of text in the statute. Now, that doesn't mean that some courts aren't still getting it wrong right now. In fact, EEOC is filing a brief on Monday in front of the 11th Circuit from a district court that when I read the opinion, I'm like, how did you graduate from law school, much less become a judge? It's like you're not even looking at the statutory text. So, there is still a problem, but I'm certainly hopeful the 11th Circuit will fix at least that opinion. So all of those elements are intended to ensure that people with an entirely wide range of medical conditions are covered. A wide range of medical conditions. So I still remember talking to a reporter, after we had issued the regulations, and she said to me, so how will this law and these regulations help people with disabilities? And this was after I described this all to her. And I said, why are you asking me the question that way? Like, why is this going to help people with disabilities, as if you're talking about other people? Like, why don't you say, how will this help us? How will this bill and this law and these regulations help everyone in the United States of America? Because there are lots of people with medical conditions that are now covered under the law for purposes of reasonable accommodations. And especially for low-income folks who do not have paid time off or any job-protected time off, the accommodation of time off from work is going to be huge for them. Okay, so it's so much more important to be sending out the word, we are all disabled. If you have a medical condition, whether it's anxiety disorder, whether it's a heart condition, whether it's you're recovering from knee surgery, okay, you are covered under the law as a person with disability. And you should be joining hands with people with more severe disabilities as one community. And to me, that's one of the important pieces of the American Association of People with Disabilities, AAPD, that is very clear about being a cross-sectional disability organization and covering people with the entire range of medical conditions, health, medical, physical, mental conditions. So, the law stands for the fact that there is no us and them, not as broadly as the original ADA Restoration Act, but still many more people are in this category of people with disabilities. And the way Carrie said when she was talking and saying she can't stand when people come up to her and say, oh, I have dyslexia, I have mental illness, but it doesn't come out about it, that's a problem. And again, that's where the disability community should be learning from the gay community. We knew that the way to make a difference in how people thought about us was we had to come out. Because often people don't know if we were lesbian, gay, bisexual, transgender. So coming out is essential for some people with disabilities, right, where the disability is not manifest. Okay, so one part of the talk, one part of my work has been about saying we are all disabled and we need to say so. But now I want to do the second part, which is we are not all equally disabled, and that makes a difference, and that matters. Okay, because now let's talk about the type of discrimination that different people with disabilities face, right? What I said to the Senate committee was, what's different is some of us experience some types of discrimination versus others. Okay? There is a difference when you have a manifest disability versus a non-manifest. Okay? You might have diabetes or HIV infection or anxiety disorder, whatever, but if it's not manifest, you're not likely to get the impact of the discrimination when you're sitting there for the job interview. It's just not. Now, you need to be covered as a person with a disability because in case it comes out afterwards and you get discriminated against on that basis, you need to be covered. And in case you need reasonable accommodation, going to the doctor, you need that protection. So it's important to be covered as a person with a disability, but you're not going to necessarily experience discrimination sitting there in the job applicant seat. As opposed to if you have a manifest disability, you come in and you're limping. You come in and your arm is crimped. And I also loved how Carrie said, crimp. It is the type of thing that only when you're in the community sort of can you use it, but it sort of feels to me like what gay people did in terms of taking back the word queer. But anyway, if you have something that's manifest, right there, whatever prejudice, whatever discomfort, whatever's going on in the mind of the supervisor, you're going to be impacted by that. Right? So there is a difference in terms of the type of discrimination between a manifest and a non-manifest. And then there is yet an additional different level of discrimination if you're coming in and using a wheelchair. It's not just that your arm is crimped up, but you're using a wheelchair, or you're blind, or you're deaf. Because then you've got the supervisor thinking, oh my God, this is going to be so much trouble. I bet you this person can't travel very well. I mean, mind you, you're sitting there, you got there for the interview, you managed to travel, thank you very much, but they're sitting there thinking, oh, I don't know if they're going to travel. Oh, it's going to be difficult. Oh, right? So yet another level of hurdle. We are not all equally disabled. We do not all experience the same type of discrimination. And from my perspective, the law we have right now takes that into account. It says under the Americans with Disabilities Act that the definition of disability is broad, substantially limits major life activity, and you have to take the affirmative steps of providing a reasonable accommodation to people with disabilities, but it does not require affirmative action. The ADA that applies to the private sector does not require affirmative action. Literally affirmative steps to counter the hurdles that we know stand in front of people with certain types of disabilities. But Section 501 of the Rehabilitation Act that applies to the federal government and Section 503 of the Rehabilitation Act that applies to contractors that apply to companies that have government contracts that are getting money from the government, those entities are required to use affirmative action to employ and advance in employment people with disabilities. Now, here's where it all comes down to words. Remember I said policy, politics, text of a statute, and then law. The text of 501 and 503 says use affirmative action to employ and advance in employment people with disabilities. The definition of disability for purposes of 501 and 503 is the definition used for ADA. So one argument that could be made is that the affirmative action has to apply to everyone with this entire broad range of medical conditions. Because look, it's the same definition. Or you could argue, which is my argument, that if you look at the purpose of the Rehabilitation Act, which is about dealing with people with more severe disabilities, more manifest disabilities, that the affirmative action component applies to the types of folks who are going to experience more discrimination. That, to me, is a basic point of statutory interpretation. Now, in the regulation, the proposed regulation that the Department of Labor has put out to implement Section 503, which applies to government contractors. So the Department of Labor is responsible for implementing Section 503 with regard to government contractors, the Office of Federal Contract Compliance Programs. EEOC is responsible for implementing Section 501 of the Rehabilitation Act with regard to federal agencies. For 15 years, we at the EEOC have said, look, there are people with what we call targeted disabilities, and we've got a list that desperately needs updating, but at least it's a list of the type of disabilities that we think we want federal agencies to be more focused on, making sure they employ people with targeted disabilities. And then we have just a whole other list that's the range of medical conditions. So we definitely, from EEOC for 15 years, have thought there should be a distinction. When the president issued his executive order 2 years ago saying that he wanted to see what's the amount on the executive order? How many people with disabilities are to be hired? 100,000? 100,000. Okay. So he said 100,000 people with disabilities should be hired by the federal government between 2 years ago and 5. So in the next 3 years, and I think we just got the numbers of it's like been 11,000 or something that's been hired. But at least that's 11,000. But in that executive order, again, it said that the agencies should set goals for themselves for targeted disabilities and then all others. So for me, when I worked on the goal setting for the EEOC, I suggested that we put down 20% as a target for people with all disabilities, even though I really thought it would probably be 50% of our workforce already had some physical and mental impairment that would be covered. But, okay, 20% for all people with disabilities, and 5% of our workforce should be people with targeted disabilities. And again, I said we need to update that list. Currently, the proposed rule that was put out by the Department of Labor, comment period is closed, so the Department of Labor is now looking and writing their final rule, which is why I say that the next entity to reach out to is the White House that will get Department of Labor's final rule. The rule itself did not make any distinction between types of disability. In the preamble, Department of Labor asked for comment about whether there should be a sub-goal for people with targeted disabilities. They had created a national goal of anywhere, they said, between 7% and 5% and 10% for people with all disabilities, and maybe a sub-goal of 2% for people with targeted disabilities. And they just asked for comment on that. Well, the disability community that put in comments said, yes, of course there has to be a sub-goal, because otherwise the government contractors will fill their ranks with, people with anxiety disorder that's medicated and people who had heart attacks and are now recovered. I mean, it's not going to get at the people that we're trying to create this additional affirmative efforts. So I certainly hope that the final regulation very clearly has, a separate goal that is about a goal for targeted disability. But even more so, I think this is something that we as people with disabilities and as people with disabilities who do not equally experience discrimination need to be out there talking about. So I think all people with medical conditions need to see themselves as people with disabilities, but I think we need to make clear that government contractors and federal agencies don't carry out their affirmative action obligations by not focusing on the people who experience additional hurdles. And you know what? I don't think that's an overly complicated message. Right? I mean, it's not impossible to say both of those two things. But at least based on the development of the Department of Labor regulation, it certainly seemed to me that there was a problem with people grasping both sides of that. And I think that having people understand that needs to come from us as the disability community. So stay tuned to the final regulation, which I'm certainly hoping will be very clear in terms of targeted disability, because then I think that can finally change the unemployment rate of people with disabilities, because that unemployment rate is being based on people with much more severe manifest disabilities than the people that are covered under the ADA totally. Okay, that's my spiel in terms of we are all disabled and why we need to say so, and we are not all equally disabled and why that matters. Let me stop and take a few questions or comments, and then actually keep you on schedule pretty much for your conference. Yeah.
I come from a family with a lot of doctors, and what you were talking about, has the broad medical community, rather than self-drafted, gotten involved with this? Not the people who may testify, who are out there, but has there been any approach from the advocacy, your community, approach the whole medical community, because they are issuing the reports that lead to the certifications or not, and I am sure they need a lot of education.
That's a great point. In terms of, so the question for anyone who's listening to this on the web afterwards is what sort of outreach has been made to the medical profession, because those are the folks who are often writing the reports, etc. So The first piece of education to go to the medical profession is to explain to them that there's a difference for the definition of disability for a report that they might be writing for someone who's trying to get disability benefits. There, the report needs to talk about how the person can't work, because that's the basis on which you get the benefits, as opposed to someone who needs to be noted as having a disability for purposes of an anti-discrimination law where the person is trying to work. There, what they need to be educated about, and I think there's some efforts, but there needs to be even more, looking at Paula Perlman there, who's one of the total great people doing disability rights and who has thought about ways that we need to do education, right? That the doctors need to understand that now major life activities includes a major bodily function, okay? You don't have to show how that person's impairment affects their ability to lift or stand or, they can just say it affects the neurological system, substantially limits the neurological system, substantially limits the musculoskeletal. The more that you get the doctors to just say that about the bodily function, the easier it will be for the person to then turn around and say, but I'm qualified for the job. I mean, there was always this problem. We were trying to show how disabled someone was and what they could do functionally, but then they had to turn around and show how they were qualified. And sometimes it didn't matter, sometimes it did. One of the nice things about having major bodily functions here is it makes it clear that that's all the doctor needs to say. And you can be, I am, without my medication for my anxiety disorder, there's no doubt that I'm substantially limited in my neurological function, right? All you have to do is go look at my record, my psychiatric record, and you can see that. Okay? So it's like that's all the person needs to say. And then the person is covered. And again, for purposes of time off from work, to go to the doctor, that's important. So I think that there does need to be education of doctors. In this amicus brief that we're filing, again, there was, in our amicus brief, we were explaining how the person was substantially limited in lifting, and my staff attorney had said, we don't talk about major bodily function till the end, and he knew that I'm a big start with major bodily function person, but when I looked at the case, the affidavit from the doctor was just about lifting, and various other activities. So I thought, no, we have to go with the lifting first, but it'd be really great if the doctor's affidavit had said was substantially limited in the neurological function, which is what we also said in our amicus brief. So I think that's going to be a huge piece in terms of then having those doctors be able to explain to their people coming in, and you know what? If you're having trouble coming to see me, getting time off to come to see me, you have a federal right to do that, and to give that person information. That's how we start spreading around the idea that, we are all disabled in the context of anti-discrimination protection. We're not all disabled in terms of getting disability benefits, because there you have to show you're unable to work. Yeah.
How many cases, if any, are being brought under the regarded as prong, and how are those cases going?
Right. So the question is, how many cases are being brought under the regarded as prong, and how are those cases going? So again, this is something where I've shifted my position of how I think things should happen. I felt very strongly in the beginning that, let's just bring any case that does not have reasonable accommodation, let's bring it under regarded as, so that we really start nailing down for the courts how broad that is. The problem, though, is that because to show regarded as, you also have to show the causation, so you're sort of into the merits of your case right in the beginning. And given that we also wanted to really drill down on the fact that so many disabilities were clearly covered under prong 1, right? So epilepsy, diabetes, cancer, heart condition, even if reasonable accommodation wasn't at issue, I now believe that we should just say, look, that's prong 1, we're covered, and then get into the causality point, So I have now, the EEOC has brought about 62 cases under the ADA Amendments Act. And I categorized them at one point, and in fact, I am going to try to write that down. I am trying to create a website, that's feldblum.com, because the idea of trying to get anything on my page at the EEOC it's like, forget, we have one web person for the entire EEOC. The guy's a little busy. Okay, so he might not be able to, so I've just decided, okay, I'm just going to my own webpage, highfeldblum.com. If you follow me on Twitter, you'll find out when it's live. But, for example, one of the things I want to do there is categorize the cases that EEOC has brought. There were about 3 or 4 where we did also argue the regarded as. Because I do want the courts to start getting used to that. But let me tell you, in this amicus brief we just filed, again, it's like this judge, I don't know. On the regarded as, he said, well, it's going to not last more than 6 months. So you're not covered under the 3rd prong. And I'm like, have you read the statute? It's transitory and minor. I mean, he didn't even analyze and minor. And there's no way he could have said that what this guy had was minor. So again, I'm just hoping the silver lining, I hope, is that it was such poorly reasoned on the district court level. The 11th Circuit, even the 11th Circuit, is going to have to, I hope, reverse, and make that clear. So I think there's a lot of power in it, but, we clearly have work to do even under prong 1. So that's where we're heading. Yep.
This is a question about retroactivity of the ADAA. And, was it on people's minds during negotiations? Do you have any insight on that?
Yeah, I mean, we had a very short discussion. So we were sitting there, so we were negotiating this in basically from February till May. So it was introduced in May of 2008. So we created an effective date of January 2009, as 6 months. And we specifically talked about should it be retroactive, and the business community was like, no way. And from our perspective, it was more important. I mean, we didn't really have a good argument. I mean, we had an argument for retroactivity based on this was always the intent, but not a very strong one, given where the Supreme Court had gone, So it wasn't that important. I mean, among the scheme of things, it was more important to get the law passed. So, and pretty much every court has said it's not retroactive, and I think that's the right result. Wait, does anyone else have a say? You were waiting, okay. Well, but the things, why don't you talk to me right afterwards, because I want to keep you guys on time. Thank you so much. Thank you for existing.
Fantastic. We have a speaker gift of some local chocolate.
Oh, excellent. Thank you.
Thank you so much.
Excellent. Thank you, guys.
Yep. Well, that concludes our speaker portion of the conference. We'll take a few minutes break, like 5 to 10 minutes, and then we're going to kick out everyone who is not a law student or an aide or providing cart services, because we're going to have an internal discussion about NALSWD priorities for the future and elections and how we want to go from there. But before we kick everyone out, please get a chance to talk to the commissioner, and also Ollie Cantos is here from the DOJ. If you want to raise your hand, if you haven't gotten a chance to meet him, he was great to come today, so please stop by and say hi as well. Great, thanks.